Good afternoon and welcome to the Law and Crime Network. I'm your host, Vincent Hill. We've been covering the murder trial of Frank Gifford. He is accused, he's on trial right now for the murder of Timothy Coggins. Now, this is not a recent murder. This murder actually took place 35 years ago in the state of Georgia. And I remember in 1983, I was about 10 years old. And the biggest news in Georgia was that the Atlanta child murderer was arrested and later convicted in 1983. But just 50 miles outside of Atlanta in Griffin, Georgia, there was a family, the Coggins family, that was dealing with the death of Timothy. He was stabbed multiple times. He was dragged behind a truck with a chain, and his body was left in a field to be discovered like trash. You can see Timothy there on the screen on an outdated photo. We don't know exactly when that was taken, but again, this was in 1983. Joining me right now is Law and Crime trial analyst Elura Nanos. How are you?
Good, thank you so much. Nice to be here.
Always a pleasure to have you on. So, Elura, here's what we're dealing with. We're dealing with a case that's 35 years old. A lot of evidence was either lost, not recovered, you name it. And also, you know as well as I do, when you're dealing with cases this long, that memories fade, people die, stories change. So how big of a deal is all of that when dealing with this trial in the murder of Timothy Coggins?
Well, it's a very big deal because anytime the critical evidence, whether it be physical evidence, whether it be testimonial evidence that relies on memory, anytime that stuff gets really old, it runs the risk of being less accurate and less reliable. However, there are some specifics to this case that the lapse of time may not be as bad or as harmful to the prosecution's case as maybe they might have been in other cases. One such area is the DNA evidence. In 1983, the DNA science wasn't there. DNA science has come quite a long way since then. So in that sense, the lapse of time has the potential to be helpful to the prosecution because it exists now and it didn't exist then. So that's one aspect that lapse of time may end up helping the prosecution's case. What I'm really interested to see here, Vincent, is how the lapse of time in terms of social attitudes is going to affect the outcome in this case. Because this is something that happened all the way back 30 years ago. And so many of us know that attitudes, particularly attitudes about race in the South, were very different then. So I wonder if jurors might be more willing to accept a purely racially based, racially motivated killing. I mean, this is essentially a lynching in the way that it has been alleged.
Right.
I really wonder if a jury might be more likely to convict because it's so old, because they're bringing this idea that, hey, things were so different back then. And I wonder really how that is going to affect them while deliberating about this case.
Yeah, I couldn't agree more. And one of the things I noticed about the jury makeup, I believe it's 10 whites and 2 blacks. So it'll be very interesting. And yeah, I spend a lot of time in Atlanta, Georgia, 50% of my time there. I know Griffin, Georgia, it still has, you know, what's known as the good old boy system, even though we're in 2018. So I'd be interested to know about that. And you mentioned DNA. I always say DNA is "and" spelled backwards because, yes, you can have DNA, but you also need and DNA and a confession, DNA and a witness, DNA and this. So I'm curious to see how this trial goes as it moves along. We're going to divert from that for just a second, and we're going to look at the Officer of the Week. Take a look. Hey, welcome back to the Law and Crime Network. That was a recap of the Marine murder trial that we've been covering here on the Law and Crime Network. Still with me is Elura Nanos. Elura, there's a lot of things going on with this trial, and I'll just point out a few here. The gun, obviously, it was recovered from someone else. The DNA that the defense says was found under the victim, Jonathan Price's fingernails. And then you have this Antonio Fry, who had the gun. He sold it to an ATF agent, but there was another bombshell that came out from the defense, someone by the name of Antonio Taylor, who a tip said was involved in this murder. And guess what his description is? A male black with dreads. one of the defendants on this case, Quincinio Canada, is a male black with dreads, but police had this tip about Antonio Taylor. So what's your take on all of this as far as what's going on in that courtroom?
Well, I think all of these statements about the defendants and what they look like and what the perpetrators look like, these are really going to be the heart of this case, because the defendants in this trial are asserting the defense of it was someone else. It was a mistaken identity.
Right.
So anything really that goes to whether or not witnesses can accurately identify their faces and their facial features, that's going to be really critical. And we saw earlier in the week when Megan Price was testifying, one of the things we learned is that she herself did not specifically identify the defendants from a lineup because she said she really wasn't comfortable giving a specific identification, but they did play the 911 call where she sort of generally described them. And I think that the jury here is going to be grappling with the question of whether these sort of vague descriptions are enough, where people close to the situation, the victims, said, well, they're black men, one has dreads, wearing a white T-shirt. Is that enough to link the crime to these specific defendants? Or is it just too vague? You know, we have this guy with the racially charged Facebook post, right, something like these people all look alike, which goes directly, again, it's not just that it's racist, but it also goes directly to identity and identification. We've also seen many times when cross-racial identifications are notoriously unreliable. So I think that there's a lot here, and that's going to be the heart of this case because the entire defense hinges on the idea of identification.
Yeah, absolutely. I couldn't agree more. And again, that's the Marine murder trial. That trial happened back in 2014, just 4 years ago. But the other trial that we're covering, the murder trial of Frank Gebhardt, accused of killing Timothy Coggins, happened 35 years ago. So much time has passed. Timothy's mother passed away 2 years ago, just before there was an arrest made in this case. So that's very sad in itself. So let's take a recap of, and let's take a look at what's going on in that courtroom in Griffin, Georgia.
The trial.
Hey, welcome back to the Law and Crime Network. Still with me is Elura Nanos. Elura, this whole case, according to the prosecution, Timothy was killed because he was associating with a white woman. I believe Gebhardt, the defendant's old lady, as she was referred to a lot of times in this case. Of course, this was in 1983 when a lot of that was frowned upon, especially in small town Georgia. My question to you, right, a lot of people, especially 35 years later, stories change, but do those stories change because it was a lie 35 years ago, or do they change because your memory is not the same as it was, so you're filling in the gaps that you just can't remember? Does it mean it's a lie because you said, oh, it was red, and then you say it was orange 35 years ago?
Well, I think that that's a really good question. And it is, you know, it's a good point because naturally, even when we're talking about people who are committed to giving truthful accounts of things, naturally, over time, stories do tend to change slightly. And we see that time and time again. It would be unusual if the same person described the same event using the same exact words consistently over 30 years. So we do see kind of a change in memory. But I think that the issue here really is what's changing. Is what's changing surrounding details that are maybe not directly relevant to the guilt or innocence of this defendant. Are they, you know, what did you do that day prior to the alleged crime, or what did you have for breakfast that morning? You know, so much about testimony is asking witnesses to reconstruct what they were doing the days surrounding a crime. So I don't think it would be unusual if someone's recollection about minor details changed. I do think it would be very unusual for recollections about having killed someone change. You know, and that goes also for someone who is recalling having been told that someone killed someone. You know, if someone confesses a murder to you, that's one of those things that you're not likely to change your memory about over time. Maybe you would change memory of the exact words, but I mean, that's a pretty significant event. So, whether you're the person giving the confession or the person hearing the confession, I think it's dramatic enough that it would be unusual for it to change substantially in character. So, your question was, how is this going to affect the trial? The fact that people naturally, as their accounts will change. I think that jurors have common sense, and they will understand that to some degree, minor inconsistencies make sense and are totally forgivable here, and they do not indicate lack of truth. Major inconsistencies are a completely different issue. When a witness starts having trouble recalling who said something, or whether this defendant admitted to killing someone, that's, I think, where the jury's going to start to scratch its head and say, I don't know if this is really reliable. But I do think that a jury is going to sort of, through common sense, forgive minor, less relevant inconsistencies in whatever his recollection might be.
That's very well said, Elura. We want to take a listen to one of the key witnesses in this case, what's known as a jailhouse snitch, Patrick Douglas. He claims that Gebhardt actually told him about this murder. Let's take a listen to what he said.
The trial of a man.
Hey, welcome back to the Law and Crime Network. One of the things about live TV is sometimes things happen. Still with me, Elura Nanos. We've been talking about the Frank Gebhardt murder trial there in Griffin, Georgia. And just to give our viewers a little idea, Griffin's about 50 miles from Atlanta. It's heading towards Macon, Georgia. And the further away you get from Atlanta, a lot of people associate Atlanta with being the new Hollywood of the South. People are moving there faster than they're moving to New York City. But it's a very small town, even now in 2018. So I think, Elura, you alluded to it earlier, have those attitudes changed in that society, especially in Griffin, Georgia? We've yet to determine that. Of course, this verdict is not in. That jury, I believe, is 10 whites, 2 blacks. So you look at that from a different demographic standpoint, it looks pretty uneven just on the first glance. I think we're ready to take a listen to what Patrick Douglas had to say. Again, this is a jailhouse snitch, informant, if you will, who says that Gebhardt confessed to this murder. Take a listen. Hey, welcome back to the Law and Crime Network. You just heard testimony from Patrick Douglas, a jailhouse informant, or on the street jailhouse snitch. Still with me, Elura Nanos. Elura, what do you think about that testimony? I mean, the defense did a pretty good case of starting to discredit this guy. I mean, he talked about his SS tattoos, which he had to get by doing an act of violence against an African American. They didn't get into what that act of violence was, but we can only assume if it was an act of violence and it had to be violent, that it was pretty violent in itself. So what do you think of this testimony? Because I kind of get what the defense is saying. Like, why are you saying that my client said he did this when you have done this?
Well, frankly, I don't love that as a defense strategy. I don't see how showing this witness as a racist criminal somehow makes the point that he is lying about someone else being a racist criminal. In fact, there is like this underlying kind of undercurrent of takes one to know one going on here. And Douglas testified about the Gebhardt confession, and he said, when he told me, he seemed excited about what he'd done. Mm-hmm. And I think, using sort of my own common sense that I'm bringing to this, if I'm a juror and I hear, well, we have a witness who is a convicted criminal, who he's not just any convicted criminal, but he is in fact a racist convicted criminal, and who has done violence against people of color in the same environment as this defendant, and he is saying, this guy confessed to me and he seemed very excited. He was, like he was bragging about having committed this crime. The whole thing to me becomes, it makes sense, because now I'm saying, well, this is why this guy would confess. This is why Gebhardt would have told Douglas that he committed this crime, because if they were kind of two peas in a pod and they were, maybe not, I don't mean that they were working together at all, but just that admitting to this crime would have bolstered his credibility in some way to Douglas, or they would have been on, sort of the same side or the same mentality. It makes perfect sense why Gebhardt would have confessed to him. So I understand wanting to discredit this witness by making him look like something of a bad guy. But frankly, I don't think it'll work, because to me, it makes it look like this is the exact witness who knows exactly what Gebhardt would have meant.
Right. No, I think you're right. And I think the defense's attempt here was to discredit this witness. But to your point, I mean, he said himself, yes, he had to do violent acts against African Americans to get his tattoos that were covered up there in court for obvious reasons. Let's get back into the courtroom and hear more testimony from Patrick Douglas. Hey, welcome back to the Law and Crime Network. Still with me, as you can see, Elura Nanos. Elura, there was more testimony from Patrick Douglas in this case, and outside of the racially motivated aspect of this, and outside of the SS tattoos, defense will always hammer in on jailhouse snitches, because, as we know, even though they say there isn't, there's something they're trying to get out of this, whether it's time off their sentence, whatever it is, there's always something that they're trying to get out of that. So how do you convince a jury or a juror to say, oh, I believe this guy because he wants to do the right thing, versus do I really believe this guy because he just wants time off his sentence?
I think that is really the kind of key point about a witness like Patrick Douglas, because putting aside who Douglas might be in general, there's always that kind of core problem with ever using jailhouse testimony, which is the witness is there to get something. The witness is not just testifying out of the goodness of their heart. There is a reason, and that makes the witness, it brings up the question of bias, meaning that the witness is going to say something just because the witness wants to help a particular side. And I think that is always difficult to get around. And what it usually comes down to is whether the juror sort of has an independent reason to believe the testimony of that witness.
Right.
And those reasons can relate to the specificity of the witness's testimony. Like if the witness comes across as being highly credible, gives details that just makes the account independently credible, I think that can be very important. Whether maybe there's underlying facts between the witness and the defendant so that there's a reason to believe that this witness would testify one way or another. I do think it's a difficult thing to get around, because certainly Patrick Douglas stands to get something in exchange for this testimony. So naturally, he could be making the whole thing up just to help himself. And I think the jury is going to be faced with that decision to say, do they think that his account of things is credible enough that even if he were motivated to make things up, would they be able to tell? Or does he sort of seem like he's telling the truth? Because ultimately, there's no other way that they'll know. So I think a lot comes across with things like body language, word choice, how he holds up the cross. In our adversarial system, a natural part of cross-examination will always be to attack the credibility of any witness who is either getting paid or who has something else to gain from testimony. So it'll be brought out on cross-examination, and we will have to see sort of how he holds up on that question to see what his answer is about why he's testifying, and does he have a credible reason to be giving this evidence.
Absolutely. Again, we've been discussing the Frank Gebhardt murder trial. He's he's accused of murdering Timothy Coggins 35 years ago. The jury was let go early today in that trial, so we will be covering it again Monday, but we'll definitely be discussing it here during the time we are on the air with the Law and Crime Network. We want to switch gears and look at the top crime stories of the day. Take a listen. Hey, welcome back to the Law and Crime Network. Still with me, Elura Nanos. Elura, $4. I remember when I was in patrol in Nashville, I was the first officer on the scene to a shooting of a 12-year-old kid, and he was shot and killed for $5 during a dice game gone bad. And it made me realize people don't value life if you can be killed for $5. And here's a man you can see on the screen. He was a father who was killed for $4. Now, one of the defendants in this case said that he only brought the gun to scare the individual, but you know as well as I do, when you have a gun, especially a loaded gun, your intent is to use it. Your intent is to pull that trigger. So, you know, just because this guy says, oh, well, I only brought it to scare him, doesn't take away from the fact that he murdered this individual, and the sentence, I think, was exactly what he should have got. What say you?
You know, I agree. Certainly to some degree here, it is a very harsh sentence, but I mean, this is a murder. And I mean, if anything is going to justify a sentence like that, this is it. Mm. And you know, the point about it having been committed, you know, for $4, you know, I mean, I think that's a really a point well taken. And it shows us, you know, just how senseless these crimes can be. And although, you know, a person's life wouldn't have been any less valuable if the crime was committed for $100,000.
Right.
But truthfully, it just sort of makes it seem all the more senseless. And it feels more, sort of more sad because it was so needless. And, you know, your point about, you know, if you're not going to show intent, then don't show up to a violent crime with a loaded gun.
Right.
That is exactly the rationale behind statutes like felony murder rules, which say, look, you know, if you're going to commit a crime and it's going to be a violent crime and someone dies during the course of that crime, even if you weren't trying to kill them, you still bear those consequences. And I think we as a society absolutely feel that way. You're in the middle of committing a crime. We're not going to distinguish between someone who set out to murder somebody and someone who accidentally killed someone in the middle of an intentional crime. Either way, the intent is criminal intent. Either way, it's a murder, and either way, that person needs to be punished.
Yeah, I couldn't agree more, and it reminds me of the case we're covering right now, the Quincinio, Canada, and Dewan Muslim murder trial, convicted or accused and charged with killing Jonathan Price, who was a Marine during a robbery. And it made me think, like, these individuals who shot this young man for $4, I assure you this wasn't their first robbery attempt. This wasn't their first time at the rodeo, so to speak. And I'm sure as investigators look into this, there's probably more robberies that they will likely tie these individuals to. What do you think?
I think that, you know, from your police perspective, I think that's a really important point. And those of us who our expertise lies more in the courtroom as opposed to on the beat, you know, sometimes kind of can forget that because as lawyers, we're very trained to focus on what's directly relevant.
Right.
And you know, facts from other days and other crimes and other people are generally not relevant to the case at hand. But I think that from an investigative standpoint, that is so important to remember, look, if you have two guys killing someone for $4 during a robbery, or you have two guys showing up in a parking lot and shooting two people really unprovoked, totally, there is a very good chance that those people have committed other crimes, possibly other similar crimes in the past. And I think that although those other crimes don't and should not bear on conviction or sentencing directly with the, you know, with the instant case, I think it is relevant to kind of the totality of the circumstances and how we understand these crimes as a society. And in certain cases, it does become relevant on sentencing. But I think that that's a really important point. These things don't happen in a vacuum. And if someone has been convicted of killing someone, you know, in a back alley for a $4 robbery, there is a good chance that they've done something else. And although we don't use that path to convict them, it still is relevant in terms of how we process the crime.
Yeah, absolutely. I've always said a serial killer doesn't just wake up one day and say, hey, I want to go kill 15, 20 people. There's something they've done in their past that the signs and the red flags were there. We want to switch gears, get back into the Gebhardt case. We want to listen to Willard Sanders, one of the witnesses here in the Frank Gebhardt murder trial. Hey, welcome back to the Law and Crime. Still with me, Elura Nanos. Elura, you know, a few things I noticed here. It's kind of laughable, but it's not. Just to give you an idea of how it was in 1983, and sounds like now, when he was pointing out the defendant in this case, Frank Gebhardt, he described him, and I think the judge actually said, well, that looks like all three at the table. And another thing I found interesting is here's a guy who's friends with the defendant in this case, but yet he actually is the one who discovers the body. So that tells you how much of a small town that was, especially back in 1983. And he also said he contacted a narcotics agent to tell him about this body. And in my days in policing, unless I knew someone, they couldn't just call me up on the phone and say, hey, Vince, I found this, or I found a dead body, or something like that. So it kind of gives you the mindset of this small town mentality that was going on in 1983. What do you think about that?
Yeah, and I think that that's going to factor into this case quite a bit in terms of sort of setting the scene. I also thought, look, during trials, there are lots of moments where, just sort of the logistics of trial cause everybody to maybe have a chuckle or something. And here we saw several people in the courtroom erupt in laughter when the witness, when he was describing the defendant, he said, well, it's a bald-headed guy. The judge said, well, that could be lots of people. And he said, yeah, it could be everybody sitting there at the table. And although there was nothing necessarily inappropriate about the exchange that was going on, everyone in the courtroom had a little chuckle. And I actually think that it's moments like that that create just this sort of impression to the jury about the witness. And the impression I got listening was that this witness is very relaxed, relaxed enough to make, he just doesn't seem nervous. He's talking about squirrel hunting, and he's talking about being the defendant's old friend, and he just seemed very comfortable. And it's factors like that, like the comfort of the witness, that sort of subtly convince the jury that the person is telling the truth.
Yeah.
And the prosecutor did ask Willard Sanders, are you mad at the defendant? Do you have any reason to lie about him? He said no. But what came across to me is this guy, at least on a surface level, seems pretty credible. And I know that those of us who watch lots of courtroom dramas and TV in fiction, we like to believe that people who lie on the stand can do so just effortlessly. But those of us that have been in the courtroom or working with real-life criminals, we know
exactly
they're terrible at lying.
Right.
Most people are very obvious when they're lying. So that human nature to kind of assess a person's credibility based on body language and word choice and kind of overall demeanor is kind of important. And I think what's happened here is, in a quick way, we saw this witness kind of bond with the jury maybe and offer up something credible. And I think that's going to be meaningful.
Absolutely. I couldn't agree more. And, to your point, he does seem very, very relaxed, and he's not stiff. Those are all the signs of someone that is not being truthful in their statements. Most people, when they're telling a lie or they're nervous about something, they definitely don't joke around with the jury as Mr. Willard Sanders did. Hey, welcome back to the Law and Crime Network. Still with me, Elura Nanos. Elura, we just heard something, and I want to quote Mr. Sanders, if I may. I might have said that, but I think. And as a juror, and definitely as a prosecutor, those are not words you want to hear. I might have said that, but I think. What say you about that?
Yeah, that's not a great thing to hear from your witness. We talked before about jurors allowing a certain degree of inconsistency, and I think I do think that's true. But I think this goes a little bit beyond that. And when a witness says, I might have said that before, but I actually think this, now the witness is acknowledging that their statements are inconsistent, and in a way that goes a little bit beyond real minor things that we would sort of expect. I don't think that's good. I think that this witness otherwise was doing a pretty decent job. But I do think that is somewhat of a stumbling block. However, let's remember, this is a 30-year-old case. So I think that everyone is going into it knowing that there is going to be some level of inconsistency that goes beyond what we would maybe normally expect. So we'll have to just see, what that does to the overall outcome.
Yeah, absolutely. And one thing about the memory, people may think it stays, but a lot of people can't remember 30 days ago. Some people can't remember 30 minutes ago, right? Like sometimes I struggle with what I ate for breakfast. So the memory is not as strong as a lot of people think it is. And I think that showed here during that part of the testimony. We here in the studio are going to take a quick break, and while we do that, we want you to look at the Officer of the Week. Take a look. Frank Gebhardt, who is on trial right now for the murder of Timothy Coggins in Griffin, Georgia. Now, keep in mind, this crime happened 35 years ago. Timothy was stabbed multiple times, I believe over 30 times. He was dragged behind a truck and left in a field. And you just heard from one of his friends. We've been hearing a lot of testimony from people that this defendant has been incarcerated with, but we actually got a chance to hear from one of his friends. So still with me is Elura Nanos. Elura, I would have to say that, okay, yes, I could see how the defense would try to discredit a jailhouse snitch, if you will. But here's an individual that actually knew this defendant, Frank Gebhardt, and he says that he told him about this murder on multiple occasions. I believe he said twice. So as a juror, I may discredit, yes, a jailhouse snitch, but not someone that grew up with this individual. What say you?
Yeah, absolutely. I mean, not only does this witness not have any reason to lie, if anything, he has a reason to testify in a way that is positive for this defendant. He's the defendant's friend. So when someone provides testimony that is the opposite of what you would think that they're motivated to do if there were any bias, I think you take notice of that as a juror. And this guy says, you know, he was asked, did Gebhardt ever say why he killed this victim? And the friend says, he said he did it for messing with the white girl. And what we're seeing here is, well, perhaps not the tightest story in terms of detail, certainly a very consistent story. It not only is it consistent within this particular case, but it's consistent with many, many, many stories that we have seen over the years of crimes committed against black men for associating with white women in the South. So although this is just the case of one victim and one defendant, I think that that history is impossible to shut out.
Yeah, I couldn't agree more. And he also said that Gebhardt said he did it because blacks and whites shouldn't mix. So that goes to the prosecution's claim that this was indeed racially motivated, not just the fact that he was dating a white woman or talking to his old lady, but according to this friend, this lifelong friend of this defendant says, hey, blacks and whites should not mix. And you see the victim there on your screen, Timothy Coggins. We want to get back into the courtroom and we want to hear testimony from a Christopher Vaughn, who was also a friend of this defendant, Frank Gifford. Take a listen. Welcome back to the Law&Crime Network. We've been listening to testimony of Christopher Vaughn. He is a friend of the defendant, Frank Gifford, in this case. He is charged with murder of Timothy Coggins in the state of Georgia, Griffin, Georgia. Now, this is a case that is 35 years old. It happened back in 1983. Still with me is Elura Nanos. And Elura, these are his words, not mine. He did say, when discussing this case, I will kill you like I killed that nigger. And of course, the prosecution has says this is racially motivated. And again, here is a witness for the prosecution who is a friend of the defendant. So I think it leads to the credibility that, yes, he did indeed tell his friend this. And yes, it does lead to the credence that this was a racially motivated crime.
Yeah, absolutely. And I mean, I think that, you know, even calling it racially motivated is kind of, you know, soothing what this is. I mean, this is a lynching. And I think that this witness is very clear about that. And he says, look, I've been around these people my whole life. I know how they work. I know this is how people think about blacks. And meaning not presently, but at least over the course of his lifetime, and specifically back in the early 80s. And really, it's horrifying to hear all this. But there's no question in my mind that a person who identifies as a friend of this defendant, who is still coming forth and saying the defendant specifically said that he studied this victim. I mean, these people have absolutely nothing to offer that is even remotely helpful for this defendant, and is just really as bad as it could possibly get. And I just don't see this at all going well in any way for this defendant.
Yeah, not at the current time, not with the witnesses that we've been seeing that actually know him, that grew up with him, and that actually hung around him. We have about 3 more hours left here at the Law and Crime Network, a little over 3 hours. So what we're going to do here in the studio is take a break. That will give you enough time to refill your coffee because you don't want to miss the top trials going on in this country. We'll be right back. Hey, welcome back to the Law and Crime Network. That is a recap of the Frank Gebhardt murder trial. Again, he is on trial right now in the state of Georgia for murder of Timothy Coggins some 35 years ago, and the prosecution has said that is a racially motivated crime because he was associating with a white woman. More importantly, Frank Gephardt's old lady. Still with me, Elura Nanos. Elura, I know you have to get ready to sign off here, but I have one more question for you. Now, we've heard from this Christopher Vaughn, who was a friend of the defendant Frank Gebhardt in this case, but the defense dropped what I would consider a bombshell in this case some 22 years after this alleged story that Mr. Gebhardt told Mr. Vaughn. He's in prison right now, or at the time, for child molestation, Mr. Vaughn. So the defense, of course, is saying, oh, yeah, you have every reason to make up this lavish story that my defendant told you this. What do you think about that?
Well, I mean, I think that points like that are about as good as it's ever going to get for the defense in this case. And I'll say this, you know, we often see jailhouse snitches testify. And in this case, it was a friend who is now in jail. And certainly assailing the credibility of a witness or of the defendant based on the commission of other crimes is one of those things that it works sometimes, but it doesn't work all the time. It really depends on how that crime relates to their credibility. And child molestation in particular is sort of a special circumstance. Because on its face, violent crimes like sex crimes against children, it really is not a crime where credibility goes to the heart of that crime. It's a violent crime, but not necessarily a crime about truthfulness. However, knowing that someone involved in a case has been convicted of child molestation is perhaps the most prejudicial thing that could ever be introduced ever. Because it's one of those things that once we know it about someone, it is impossible to forget it. Widely considered, you know, the worst crime that could ever happen, or at least on par with the worst crime. And in this case, you know, we have a witness who gave a detailed and really pretty credible account of what the defendant said to him about having committed this crime. But then we also have this countervailing piece of information about who that witness is. And I think those things will be in tension. I think it will affect what the jury thinks about Vaughn's testimony. I think that's impossible to get away from.
Yeah, no one likes a child molester. I mean, I've arrested a lot of people for a lot of things, and when I had to make those arrests, it was not good. We want to switch gears. Elura, thank you so much for joining us. I know you got to sign off. But now we want to look at the defense as they start to break down these witnesses, these friends of the defendant in this case, Frank Gebhardt. We're going to hear cross-examination of Robert Smith. Take a listen.